Aliza, welcome to Bump in the Road. If you would, give people a little bit of background about the process of becoming a lawyer and getting a clerkship, and tell them your story.
Sure. So the process of becoming a lawyer is kind of a lengthy one. Aspiring attorneys need to take the LSAT, which involves probably 3 months of studying. People typically pay to take the law school admissions test prep course in advance. Get into law school, and it's expensive to apply. It's about $80 per application, and people are applying to mostly 10 to 20 law schools when they're applying. It's 3 years of law school, which includes several summer internships, ideally semester internships or externships as well. We're required to take a professional responsibility exam during or right after law school, and then we sit for the bar, which is an enormously lengthy and challenging exam for which we spend thousands of dollars on a prep course, invest 3 months of dedicated studying, and if you do not pass the bar, you need to take it again. That's 3 more months of studying. And then once you pass the bar, you find a job as an attorney. A lot of people decide to clerk. It's considered basically the necessary checkbox for the next job in the legal community, especially when it comes to public interest jobs. If you look at, for example, jobs for the Department of Justice or as a public defender, they require 1 year of legal experience. What that basically means is they require you to have clerked. So it's a lengthy process. It's an enormous time commitment, a financial commitment. And for people considering law school, I would say don't go into it lightly. You should only go to law school and sit for the bar if you intend to practice law.
Talk a little bit about your experience getting a very prestigious clerkship and what happened.
Sure. So I decided to clerk in the Superior Court of the District of Columbia, or DC Superior Court, during the 2019 to 2020 term because I wanted to be a homicide prosecutor in the DC U.S. Attorney's Office, and I knew that DC Assistant U.S. Attorneys, or AUSAs, appeared before DC Superior Court judges. I started applying for clerkships my 2L spring, which is second year of law school, and then I interviewed for and accepted the clerkship that I ultimately pursued in September of 2018. So I started the clerkship in August of 2019, and unfortunately, beginning just weeks into the clerkship, the judge for whom I clerked began to harass me and discriminate against me based on my gender. He would kick me out of the courtroom, telling me that I made him uncomfortable, and he just felt more comfortable with my male co-clerk. Told me I was aggressive and nasty and a disappointment. The day I found out that I'd passed the DC bar exam, so an enormous day in any young attorney's life, he called me into his chambers, got in my face, and said, "You're bossy, and I know bossy because my wife is bossy." And I was just devastated. I remember crying myself to sleep at night, crying in the courthouse bathroom, crying on the walk to work in the morning. I wanted to be reassigned to a different judge for the rest of the clerkship, which was scheduled to last 1 year, but my workplace did not have an employee dispute resolution or EDR plan, which might have enabled me to be reassigned. Confided in a few mentors and other clerks who advised me to stick it out because I needed a year of legal experience to be eligible for my dream job in the DC U.S. Attorney's Office. So I tried to stick it out. We eventually transitioned to remote work during the pandemic. In March of 2020, I moved back to Philadelphia to stay with my parents, and I worked remotely. The judge basically ignored me for 6 weeks before he called me up in late April and told me he was ending my clerkship early because I made him uncomfortable and lacked respect for him, but he didn't want to get into it, and then he hung up on me. So I called DC Court's Human Resources, and they told me there was nothing they could do because HR doesn't regulate judges, who are Senate confirmed, and we'll get to that. They told me that judges and law clerks have a unique relationship, and then they asked me whether I knew that I was an at-will employee. I reached out to my law school, to WashU Law, for supports and assistance. I found out this judge had a history of misconduct and that several law school officials, including a clerkships director and some professors, knew about this at the time I'd accepted the clerkship, but decided not to share this important information with me. So it took me about a year to get back on my feet after all this. I eventually secured my dream job in the DC U.S. Attorney's Office as a prosecutor, moved back to DC in the summer of 2021. And in July 2021, I was 2 weeks into training when I received some pretty devastating news. I was told the judge had made negative statements about me during my background investigation, that I wouldn't be able to obtain a security clearance, and that my job offer was being revoked. And then a couple days later, the U.S. Attorney's Office, or USAO, offered me an interview for a different job with the office, and then revoked that too, based on the judge's same negative reference. I was 2 years into my legal career that I'd worked so hard for, and this judge just seemed to have enormous and unchecked power over my life, career, and reputation. So I filed a judicial complaint with the D.C. Commission on Judicial Disabilities and Tenure. That's the regulatory body for D.C. judges. I hired attorneys, and in the summer and fall of 2021, I participated into the investigation into the now former judge. And we were partway through that investigation, which was just enormously isolating and painful, when some attorneys reached out to me privately to alert me the judge was on administrative leave pending an investigation into other misconduct at the time he'd filed the negative reference about me. The USAO was not alerted of this, and in January of 2022, pursuant to the terms of a private settlement, my attorneys reached with the then former judge's attorney. He issued a clarifying statement to the USAO, addressing some but not all of his outrageous claims about me. But by then the damage had been done, it was too late, and I am pretty much blackballed from what I thought was my dream job.
That is just so appalling. It's beyond belief. There's such a disparity of power between the judges and the people who clerk.
Yeah.
And there's nobody around to really witness a lot of the interaction.
Those are such important points. Yes, there is an enormous power disparity between young attorneys, fresh out of law school clerks, and often life-tenured, Senate-confirmed judges that makes it enormously difficult, if you are a law clerk facing mistreatment, to speak out. There's also, a judicial chambers is enormously isolated. It's two young law clerks and a judge working long hours behind locked doors in stressful circumstances, and there is no oversight by anyone, by a chief judge, by a supervisor, over these judges' day-to-day dealings with their clerks. And also particularly troubling, the judiciary is exempt from Title VII of the Civil Rights Act of 1964, which means that law clerks lack basic anti-discrimination protections, workplace protections. The judiciary has resisted efforts to be subject to Title VII, has resisted efforts at accountability, at transparency, and this issue is pervasive and unaddressed in the federal courts.
Just back up a little bit. Talk to me about, how does one become a judge? Because I'm curious to see how they accumulate this power and these connections and can willy-nilly destroy somebody's life.
It's a good question. So there's a distinction between state judges that are typically appointed for 10 or 15-year terms, and then they're subject to reappointment or reelection. But in my conversations with state court judges, they perceive themselves to have de facto life tenure because it's so difficult for somebody not to be reelected or reappointed once they become a judge. And then Article I judges, which means they're some courts that are created by Congress, including the DC courts. They're Article I judges. Those folks are appointed for 15-year terms, and they are Senate confirmed, which makes it enormously difficult to remove them, and they are also not subject to Title VII. And then life-tenured federal judges, also exempt from Title VII. Typically the process, it's interesting because when I talk about this issue, I explain that it's a pipeline issue, that today's law clerks are tomorrow's U.S. attorneys, federal defenders, big law partners, and judges. And when we think about who rises through the profession to and through the judiciary, it's typically white men, which affects the decision-making process in the judiciary. So right now, it's a lot of former big law folks, a lot of former U.S. attorneys, and the diversity problem in the judiciary is one that shouldn't be overlooked, although I hesitate to decouple it from conversations about judicial accountability.
What did you do after this judge essentially blackballed you?
Yeah, so while I was going through the judicial complaint process, I found a new job as a family law attorney with a boss who was very supportive of some of the advocacy work I was doing on the side, which included advocating for the Judiciary Accountability Act, which is legislation that would extend Title VII protections to judiciary employees, including law clerks. And I was writing a law journal article about my experiences. I connected with a bunch of House and Senate offices involved with drafting the Judiciary Accountability Act, or JAA, And then a House Judiciary hearing happened in March 2022 on the bill, and I submitted written testimony for that. So after my statement became public, my written testimony became public, the response was very positive, and I began throwing around some ideas to further my advocacy work with my friend, law school classmate, and now co-founder, Matt Goodman. We eventually launched the Legal Accountability Project, which is a nonprofit that aims to ensure that law clerks have positive clerkship experiences while extending support and resources to the ones who don't. We officially launched on June 1, and we are working on several initiatives in collaboration with law schools beginning this fall, kicking off a tour of fall programming next week.
Has there been any resistance from the law schools? Because obviously people knew about this judge and his behavior before you went to work for him and said nothing.
So this is an important point. This is something I write about and speak about. The response overall from law schools has been very positive, and I work with lots of deans and clerkship directors who are ready to make changes. There's been resistance from a handful of schools because they really, for a handful of schools predominantly within the T14, so the top 14 schools, they are focused on funneling as many law students as possible into clerkships. Good, bad, career-ending, devastating. It is a number of placements, period, and they really don't care whether a few young attorneys are tossed aside in the process. There's been resistance from a handful of schools, let's say about 4 or 5. They say things like, it's our policy not to warn students about misbehaving judges. We don't need your project. We know about all the judges. It's not harassment. It's just law students adjusting to their first legal job. And, for the law schools that have pushed back, we're going to be on all those campuses in the fall, galvanizing student support for our initiatives. And what we've seen is that students are demanding these resources. They are demanding that their law schools participate. They are going with us to these recalcitrant administrations. And, eventually we hope every law school comes on board. But what I really want to highlight is for law schools that are saying we don't warn students, that is wrong. That is the wrong answer. That is appalling. And you need to be more concerned about the well-being of your graduates and their long-term success in the law than about the number of placements.
Yeah, I think your long-term success reflects much more powerfully on the school than a simple placement.
You would think so, but unfortunately, in terms of data collection right now, there is so little in the legal community. Law schools are required to report to the American Bar Association, or the ABA, and to NALP, the National Association for Law Placement, data on graduates upon graduation and 10 months out, what they're doing. After that, they're not required to report any data at all, and this obfuscates law schools' role in some of these problematic behaviors. I think law schools should be required to report data to the ABA about law students and law clerks' negative clerkship experiences, as well as their employment data 3 years out, because what that would reveal is there is a group of attorneys, historically marginalized groups, women, minorities, LGBTQ folks, who go into these clerkships, and several years later, they're no longer practicing law. They're certainly not practicing law in their dream jobs. I mean, I went to law school because I dreamed of being a homicide prosecutor, and now I'll never be one. And my career is law adjacent at this point, and I think it's important to highlight how many young attorneys are being tossed aside through this clerkship process.
That opens up a really interesting opportunity for you, though, not only to collect data, but to really make a difference for people. Once you have the data, how do you see this proceeding?
Yeah, so we're working on several data collection and analysis initiatives. One of my nonprofit's initiatives is a workplace assessment of the federal and state judiciaries, which is finally going to answer the question, how pervasive is harassment in the judiciary? So we are going to be sending that workplace assessment to the past 10 to 20 years worth of law clerk alumni at various institutions. And then we are going to report that data to the ABA, the American Bar Association, to the judiciary, on our website, in forthcoming legal scholarship, and to lawmakers. How I see it proceeding. So there is this bill, the Judiciary Accountability Act, or JAA. I hope it passes. We will keep pushing if it doesn't, each year until it does. I think that data will inform the scope of the problem, and that is the first step toward crafting effective solutions. The judiciary has really been able to evade transparency, to evade scrutiny. there is really no data on the number of judges who are harassing their clerks. Once we can point to data, I think we'll be able to make an even stronger case than we can right now that reforms are urgently needed. I mean, I know anecdotally from speaking with current and former clerks, from the folks who reach out to me every day to talk about their experiences, that this problem is pervasive. In the rare instances when survey data is leaked, for example, some circuits, like the DC Circuit, conducted an internal workplace survey in 2021, and that data revealed that 57 law clerks and other judiciary employees reported harassment or retaliation. An additional 134 witnessed or heard about problematic behaviors. There are 12 federal circuits. If you multiply that by 12, there are over 600 instances of harassment or retaliation, at least, per year. And yet when we look at the only data we have on this issue is the Judicial Conduct and Disability Act complaints, where almost none are filed each year by law clerks. And that enables the judiciary to say this isn't a problem. Well, there's an enormous data mismatch between what I know anecdotally and what the judiciary reports.
You know, the discrimination is bad enough. It's horrific. It's unpardonable. But the retaliation, what is it in the society of law that encourages this type of behavior or supports this type of behavior?
That is a great question. So there were House and Senate hearings in 2018 and 2020 about judicial accountability, and they highlighted some law clerks' stories of mistreatment. But it wasn't until 2022 that stories of retaliation, mine and a law clerk who is suing judiciary officials a federal defender in the Fourth Circuit is suing judiciary officials for retaliation, that this issue got a little bit more play in the media, and that's important because it's not discussed enough. Retaliation in the legal profession is insidious. It is the formal things that I am talking about, negative retaliatory references, which are difficult to challenge because in many states there's a qualified opinion privilege, which means that the judge can say, well, these are my opinions. And it's hard to access the reference in the first place because it's a government employer. But it's a lot more insidious than that. Judges have enormous power over their former clerks' lives and careers. A judge's reference can make or break a law clerk's career, and a negative or even lukewarm reference can really destroy their career prospects. And whether it's something formal, like a phone call or a letter, or spreading malicious false rumors about poor performance during the clerkship, which judges can do, and employers can always seek out a judge's opinion. The issue is that there is enormous deference granted to judges in the legal community. These are the most powerful members of the profession. And legal employers, when they're considering candidates, just do not want to anger a judge because they feel that this will threaten the success of their future prospects appearing before these judges. I mean, when we think of one of the things that I want to do long-term is connect more employment attorneys with mistreated law clerks who need legal representation. Even attorneys who work on these cases, work on employment discrimination cases, are hesitant to represent law clerks going up against judges in the jurisdiction where they represent paying clients. There is fear, there is cowardice in the legal profession, and it's really time for people to, say no, tell these judges to stop.
It's interesting. By virtue of going through this horrendous experience, you are positioning yourself to actually have an enormous amount of power moving ahead as you develop this data. It's an interesting turn of the table, isn't it?
It is. That's an interesting point. Yes. I hadn't thought of it that way. But yes, I am very grateful for the support that I've received so far, and it's been a positive response, but I'm excited for what's next. And I think some of these data collection and analysis initiatives are important. For judges who are doing the right thing, which is the majority, they shouldn't worry at all about the initiatives I'm working on. For the misbehaving ones, a judiciary commitment to enforcing the rules and implementing new ones will concern them.
If you really get enough complaints about a judge, it seems almost like the law students can blackball that judge in terms of just avoiding a clerkship with them.
That's one of the things we sort of hope from our centralized clerkships reporting database, which is the other initiative we're working on, is, well, I should probably back up and explain what it is. So right now, if you are a law student and you are considering clerkships, there is no way for you to know to avoid judges who harass their clerks. When I pose this question to student groups and I say, so you want a clerk, you want to avoid judges who mistreat their clerks, what would you do? They say either I have no idea or maybe I would talk to someone. The issue is that law clerk to student information sharing is inefficient at best and ineffective at worst. The information about misbehaving judges is not getting from the law clerks who face the mistreatment to the law students who need the information. And law clerks who've been mistreated are notoriously unwilling to report back to their law schools, let alone report accurately to students who contact them considering the clerkship. What we're trying to do with the Legal Accountability Project is to centralize and democratize information about judges, so as many law students as possible have as much information about as many judges as possible before they make what is obviously an enormous decision about their career paths. We'll be having law clerk alumni create an account with us and report into the database about their judge and their clerkship. Good, bad, we want to hear everything. There's lots of information, not just about mistreatment, lots of other things you'd want to know before clerking. How does the judge provide feedback? Do I get writing experience, courtroom experience, all kinds of things. And then law students at the participating law schools will be able to read all the reports, not just their alumni's reports, but the reports for all the other law clerk alumni. So what I'm seeing as I'm speaking with judges is that judges are excited about the database because they understand that positive reviews will bolster their clerkship applicants, will make them look better. So I have judges reaching out to me, sitting federal judges asking, when can my law clerks report into the database? And I say, well, they have to go through their law schools. Their law schools have to be participating. So judges understand that this is a good thing for them. And as you mentioned a minute ago, yes, what I hope is that for judges who are misbehaving, law students will stop applying. Unfortunately, I see a couple things in the clerkship application process right now. I see that judges are disproportionately mistreating women, minorities, and LGBTQ folks, meaning that it's men, particularly white men, who are still seeking these fancy clerkships. They will ascend through the profession and to the judiciary, and it's historically marginalized groups who are left behind, foreclosed from important professional opportunities. And I also see some law students who hear some information that's troubling about a judge and they say, well, I can handle it. Well, first of all, you shouldn't have to. And second of all, there is no guarantee that it's just 1 year of your life. Your judge, as my story illustrates, could ruin your entire career. So it's really about evaluating all the information. We hope lots of law clerk alumni will report on their judges so that people can really evaluate, okay, there's one negative report about this judge and 50 positive ones. Let me evaluate all the information. If there are 50 negative ones, perhaps it's a red flag. You should not apply for a clerkship with this judge. It's just about sharing information in a place where it is just sorely lacking.
Why do you have to go? Why does a lawyer in a clerkship have to go through their law school? Why can't they go directly to you?
For the database?
Yeah,
so we are working with law schools for a couple of reasons. First of all, the database is a subscription model. So law schools will pay us $5 per student per year to protect all their students against harassment. The interesting thing about clerkships is different from other legal jobs. It is totally centralized within law schools. It is their purview, their domain. They have resisted any efforts to centralize this previously, to take this outside the hands of a clerkship director who works in a law school. We're working with law schools because I see them right now as a big part of the problem, but also the biggest vector for change. Several years out of law school, if a young attorney decides to switch careers and clerk, they will go back to their law school for resources, for recommendations, for training. When we look at law school staffing within a career center, there's typically a private sector person, a public sector person, and a clerkships director. Out of your staffing in a law school, you have one person whose sole job is to funnel people into clerkships. That says something about law school's role in the problem and why they should be the first to step forward and make changes.
Talk a little bit about their role as being part of the problem. I can see part of it is data. You know, if you're rewarded for the number of clerkships that people get, that can turn out to not be the best metric. But what other responsibilities do law schools have, and how can they improve?
Yeah, that's a great question. So I think the biggest responsibility that law schools have is to warn their students about judges they know to mistreat their clerks. I think that is the first thing they should all be doing. There are a few law schools that conduct a post-clerkship survey. So they survey their alumni and they ask them to write a report about their judge and their clerkship. Very few schools even do that. Very few schools keep it in a searchable database. What they do keep track of is how many people clerked, their names, contact info, and who they clerked for, which signals to me that their goal is to funnel as many students into clerkships, particularly federal clerkships, particularly fancy appellate ones, as possible. Law schools should be doing a couple things. They should be collecting data, they should be warning students, they should be discouraging them from applying to judges who mistreat their clerks, and they should be fostering honest dialogue on every law school campus about the full range of clerkship experiences. The third aspect of my nonprofit's work is fall programming. I'm visiting more than 20 law schools in the fall and more in the spring, where I'll be sharing my story, talking about the scope of the problem, and proposing solutions. Every clerkship application cycle, enormous amounts of ink is spilled. Lots of people speak publicly to highlight the rosiest of circumstances when a judge is a lifelong mentor, when this job confers only professional benefits. Very few clerks speak about the worst of circumstances, which is what I'm trying to highlight. And when I look at the schools who are pushing back, there is one school that's trying to block my visit. They've refused to speak with me. Their clerkship director is trying to pressure the student groups to cancel my visit in favor of alternative programming run through her, the clerkship director. There's one dean who's refusing to speak with me and purveying some false information. These are the same law schools that are sending an enormous number of clerks into clerkships that they know are bad. And that is deeply troubling. My intent is not to discourage anybody from clerking. When I talk to students, there are lots of times when I'll say, you should definitely clerk. It sounds like it would be a great experience for you. But it should not be about the prestige of the clerkship. It should not be about the number of placements, period. It should be about having a good experience. And one of the things some students highlighted for me recently that I think is very important is that a clerkship should be about professional training. It should be for folks who want to become trial attorneys, prosecutors, public defenders, folks like that, to spend a year learning how to practice law before judges. Perhaps the best way for you to get practical experience is to clerk at a state court or to clerk in some kind of faraway place and perhaps a less prestigious clerkship where you get better experience and better mentorship. Those are the things I'm trying to highlight for law schools.
If a law school doesn't subscribe to your service, can a student go directly to you and pay the fee?
We're not going to run the database that way. We want to avoid a free rider problem, which is people not paying and then accessing the services. We want to encourage every law school to participate, and the best way to encourage them to do that is to say, your law clerk alumni will report into the database, your students will get access to all the resources. We want to see correspondence between alumni reporting into it and students accessing it.
How has this experience impacted you personally, and how has it changed you on both an emotional and a professional level?
It's a good question. You know, I went through the judicial complaint process a year ago. It was enormously painful and isolating. The investigator who was reviewing my complaint said things to me like, you must have done something wrong because the judge hired you in the first place. My only interactions for like a 6-month period were with my attorneys. I hadn't told my family and had no support from them. It was enormously isolating. It really changed the way I interact with my friends, with my family, and I appreciate the public support. I think it's been enormously empowering to speak publicly, and I know that other law clerks who've spoken out, the response hasn't been so positive, so I appreciate that. But it's certainly changed the way I look at the legal profession. When I think about anti-discrimination laws and tort laws and who they protect and who they don't, they protect the powerful. And I think that our laws should protect the less powerful. It's definitely, I consider myself now to have a law-adjacent career. I don't see myself ever practicing law again, although I do plan to maintain my bar license. And sometimes I'll think about the advocacy work I'm doing now and how people in the legal community perceive me and think, well, there are certain legal jobs I could never have anymore. I could probably never work as a prosecutor. And it's so sad that the legal profession is that way, to think that because I've spoken out against my harasser, against a disgraced former judge, that I can no longer work in a profession where I appear before judges. And I hope to ultimately change the profession so that we are empowering law clerks to speak out, to stand up for themselves, and to create a culture where we are believing and affirming clerks, encouraging every young attorney to bring their full selves to work every day. Nobody should be mistreated because of their identity or their personality.
Now, you talk about isolation. Did you find some friends abandoned you and others stayed with you? What was your experience with your peer group?
Definitely. I definitely did. But I made some new friends along the way, so that was nice. Definitely some friends fell away during the process. I didn't confide in too many people when I was going through the formal judicial complaint process, and some were supportive and some were not. It's interesting to think about the response from the DC legal community, which is where I was practicing law. Now that I am running a nonprofit, the response has been very positive. But at the time, when I was going through the judicial complaint process, I knew that the former judge who mistreated me had mistreated other clerks, had mistreated female attorneys who appeared before him. And I reached out to so many female attorneys, and almost no one would speak with the commission investigating my complaint. They said they would never file a complaint against a judge because he would retaliate against them, and my complaint would likely be dismissed. Nothing would ever happen. He's a judge. There's nothing you can do. I really experienced the effects of women attorneys climbing the ladder of success and then just kicking it down behind them.
Do you think there's a place in your database at some point in the future for female attorneys? Practicing attorneys?
What do you mean?
Well, or not just women. Do you think there's a place for lawyers anonymously to also bring up issues they have with judges? Because the idea that you can't bring anything up because you'll be retaliated against really is pretty terrifying.
That's an interesting question. We have received questions about broadening out the database to other areas of the profession, but it wouldn't be the clerkships database. I mean, the clerkships database is for people, young attorneys considering a clerkship, and then folks reporting on their clerkship and their judge. Whether we do another database for attorneys reporting on judges, I'm not sure yet. There is this website called the Robing Room that some folks kind of can compare our database to. It's not like that at all, but it is a place where people report anonymously on judges. It concerns me. I've talked to a couple clerkships directors who've referenced the Robing Room and said, we send young attorneys, we send students to the Robing Room to read about these judges. That's really just not sufficient information.
What kind of information do they have?
They do rate judges from the friendliest to the least friendly in terms of people who've appeared before them. And while it's important to consider how judges are treating the attorneys who appear before them, it's a little bit different from how they treat or mistreat their clerks.
If you could go back, would you handle your set of circumstances any differently? And if so, what would you do?
It's a good question. I've thought about this a lot. In May of 2020, when the judge fired me, I reached out to HR, but I decided to wait to file my judicial complaint until I'd found a new job because I feared the judge would retaliate against me. He ended up, retaliating against me anyway, and it makes me wonder what would have happened if I'd filed my complaint earlier. So I do think about that a lot. I do wonder what would have happened if more former clerks had filed complaints against this judge, if more folks if I'd be able to convince more people to appear before the commission investigating him. But I don't have too many regrets about that time. I did what I thought was best at the time. And honestly, when I was clerking and when this judge was just severely harassing me, I thought, once I'm finished with the clerkship, I'll be past this. I did not understand the enormous power that this judge would have over my life. And I don't know how that would have affected me. I don't know if I could have done anything differently, but I wish I'd just understood the enormous power he would have over my life. And that is why it is so important for me to be sharing this message with law students considering clerkships. There are some clerkship directors who say to me and say to students, it's just a year of your life. You can live anywhere for a year. You can endure anything. That is outrageous and appalling advice, especially in the face of the story I'm sharing and the message I'm putting out there. Is not just a year of your life. You should really consider the enormous career move that this is to accept a clerkship with a judge.
I was going through some of the material on the web, and there's a Ms. Warren who also had a horrific experience with a judge. Can you tell a little bit about her story too?
I want to be careful because she does not speak publicly very often, but Olivia Warren did clerk for the late Judge Reinhardt, and she clerked in the Ninth Circuit at a time when there was no employee dispute resolution or EDR plan in place. It was back in 2017 or 2018, I believe. And when she tried to report, she couldn't receive any assurances from judiciary leadership about confidentiality. She ultimately testified before the House Judiciary Committee in February of 2020. And I watched her testimony when I was a law clerk facing harassment, unsure where to turn for help, and I found her public statements to be very empowering. And the public response to her testifying was not so positive. And some changes have been made, but they've been insufficient. And she wrote in the Harvard Law Review that the changes that were made were insufficient.
Just, I'm going to quote from an article that I read so people get the impact of what was happening. Ms. Warren said that the judge had indicated he would never again hire female clerks because women could not be trusted.
Yes. And so it's interesting you bring that up because I've cited that quote in some of my written statements as well. Right after the Kaczynski allegations were publicly reported in 2017, there were a group of judges who made statements like, I will not hire any more women so I can avoid accountability for these problematic behaviors. And at the 2018 Senate Judiciary hearing, I think Senator Dianne Feinstein or Senator Kamala Harris, who lived and worked in California and were aware of these Ninth Circuit problematic behaviors, brought that up with the administrative officer for the U.S. courts. They basically dodged the question and said that wasn't happening or that was overplayed. That is absolutely a sentiment among some judges to just not hire women to avoid any allegations. And because the judiciary has refused any efforts to report hiring data, which is one of the problems the Judiciary Accountability Act would solve, we really can't pinpoint what percentage of judges are just not hiring women.
That's mind-boggling. Do you have any regrets about going to law school?
Oh gosh, I think about this a lot too. I appreciate my law degree. It's helpful for the work that I'm doing now. Sometimes I look back on my time at WashU Law and I think fondly about the relationships I made with friends, mentors. Sometimes I question, knowing what I know now about their knowledge of the judge's problematic behaviors at the time I accepted the clerkship, whether I should have gone to WashU. So I think it's more looking back and wondering whether I should have gone to the law school I went to. I'm not sure. I would really caution people to think hard before they go to law school about whether they want to practice law.
It's a valuable degree, though, in terms of training your thought process. And that has lots of applications for a lot of different career opportunities.
Yeah. And I also met my friend and now co-founder, Matt, at WashU. So that was valuable. We are still trying to engage with WashU. Their deans have said to me, it is our policy not to warn students, which is appalling. They have kind of resisted our initiatives, which is frustrating, that my alma mater is not going to be one of our flagship partners. But we're not giving up because there is a whole generation of attorneys who need these resources, and we're not going to give up on any school, no matter how much they push back, no matter how much they seem not to want us there, no matter how much they seem to resist efforts at reform. A judge said to me recently, I think your alma mater should be the first to step forward and make changes to protect the next generation of law clerks. Somebody has to be the first. We're excited to announce some law school partners this fall, and we will circle back next year with everybody who has said no or not yet. We're not giving up on any schools.
I don't think I would rephrase the school's perspective. I don't think it's about warning students. I think it's about just providing data and letting them make their own decisions.
I think it is, definitely. And also explaining to them how to evaluate the data. As we said earlier, perhaps there's a difference between having 50 negative reports and having one negative report as to how that should be evaluated. I really think that law school officials at least need to underscore the negative implications of a bad clerkship experience on somebody's life. So,
what advice would you have for somebody finding themselves in a terrible situation like you experienced? What would you tell them to do?
I would tell them to do a couple things. Document everything, keep records, confide in people and keep track of who you've confided in, speak with an attorney, or reach out to me and I will try to connect you with an attorney. But I think ultimately it really is about reporting, whether internally to your courthouse, whether to your law school, filing a formal complaint. If folks are not reporting on their experiences, if they are not standing up for themselves, we are perpetuating a culture of mistreatment and misconduct in the judiciary. And I know it's enormously difficult. As I say that, I think about these issues a lot and the implications for a law clerk facing mistreatment going up against a judge. When I say creating a culture of reporting, are law clerks really in a position to do that? I think they are, and I think they need to. Judges have been able to get away with just outrageous misconduct for far too long, and it's because they're creating a culture of fear and silence in the legal community. We need to all push back against that. It's everybody's responsibility.
Fast forward 20 years. What is the judicial clerkship experience going to look like, and how will you have impacted it?
Yeah, so this year, we hope that our database will supplement law school's existing resources. Several years from now, we intend to have supplanted every law school's resources. So we will be the go-to place, the centralized clerkships reporting database, for every student considering a clerkship from every institution. We also intend to create an employment attorney database to connect employment attorneys with mistreated clerks who need assistance, and working on several other initiatives as well as some policy changes. In 20 years, first of all, we will be involved in the judicial appointments process and we'll be appointing better judges, because part of it is when we look at some of the people who become judges, I don't think there's enough scrutiny on how these attorneys have treated their colleagues, how they have treated their subordinates, and we should be digging deeper and thinking of judges as employers running a small workplace and not just folks whose political philosophies we agree with. And then I hope that the Judiciary Accountability Act will be in full effect and that law clerks will be protected by Title VII. And it's just the first step. I mean, there are enormous workplace policies that need to change in the judiciary, and I hope to deeply, deeply affect those. There's a lot more work that needs to be done, and I'm excited to play a role in that.